We have breaking news coming to you out of Washington, D.C. Just this afternoon, in a surprise timing decision, the Supreme Court has decided to block the enforcement of the OSHA ETS. What that means for employers is coming up next on Employment Law After Hours. Thanks for tuning in to our channel for all the breaking and updated news regarding the OSHA ETS. As I indicate, the Supreme Court has decided to block the enforcement of the OSHA ETS moving forward, pending resolution of the ultimate litigation down at the trial court level. On the other hand, the Supreme Court decided to uphold the enforcement of the CMS Vaccine Mandate for many healthcare providers. So we'll have another episode coming to you soon on the enforcement of the CMS Vaccine Mandate. Now, shifting back to the OSHA ETS, what does that mean for employers? Well, right now, they do not need to comply with the masking, the testing, or on the other hand, a vaccination mandate as prescribed in the ETS. The enforcement of that entire ETS is currently technically stated. And what that ultimately means is that OSHA is not going to enforce the ETS, but technically OSHA could continue to litigate the case at the trial court level. But again, we think that's highly unlikely, and ultimately the OSHA ETS is dead in the water, so to speak. However, what does that mean for employers? At this time, if you have implemented an OSHA ETS policy and would like to do away with those requirements, you can rescind that policy and you should notify your employees accordingly. However, employers can decide, if they wanted, to continue to enforce masking or testing, or as we've indicated in prior episodes, implement mandatory vaccination policies for their entire workforce. But again, you are no longer required to unless you're one of those healthcare providers that has to follow the CMS vaccine mandate. So what is the future of OSHA's regulations? Well, we plan to release an episode in the future discussing the future of OSHA's regulations to curb the spread of COVID-19 in the workforce. However, you should note that in conjunction with the issuance of the ETS, OSHA also filed formal notice and comment regulations. That notice and comment period actually ends on January 19th. Following that date, OSHA may decide to ultimately implement non-ETS regulations that look similar to the ETS. Those regulations would not be impacted by the Supreme Court decision. However, we fully expect that litigation would ensue on those regulations as well. But today, on January 13th, employers with 100 or more employees do not have to abide by any OSHA ETS. Obviously, stay tuned to our channel and we'll update you with any changes that may come from OSHA's issuance of formal regulations that may look similar to that ETS. Again, we continue to appreciate all the new followers and subscribers we've received over the last couple of weeks as we've issued new episodes concerning the OSHA ETS. We hope you stick around for additional information that we post on a routine basis for employers and employees, covering everything that they need to know in the workplace. We know this comes as shocking and surprising news to you, but we hope you are able to enjoy the rest of your week and able to relax for a moment knowing you do not need to rush to implement any regulations by February 9th. We hope you have a great rest of your day, and thank you again for staying tuned to Employment Law After Hours.